Welcome to Leas Cotidianas, or Everyday Law, where we discuss the laws that affect you every day. Today we will be discussing medical malpractice claims, and in particular, claims that we may have for our elderly. Joining us today, we have Wayne Toth. Wayne Toth is an attorney here in Atlanta, Georgia. He has been practicing in the area of medical malpractice claims, and Wayne has the unique perspective in that he has worked both on the defense side of those claims and now focuses his practice primarily on the plaintiff side of those claims. He is a graduate of the University of Pittsburgh and is also a graduate of Georgia State Law School, where he has both an MBA degree as well as a JD degree. Thank you very much for joining us. Appreciate it.
Thank you for inviting me.
All right, let's go ahead and talk about medical malpractice claims. I know people hear that term, medical malpractice, but can you just give folks kind of an overview of what is a medical malpractice claim? And simply because a medical procedure goes wrong, does it really mean that there's an actual lawsuit in the offing or not?
Yeah, great question. A medical malpractice claim, when we talk about them, really encompasses any care or treatment a person may have received by any healthcare professional or entity, such as a hospital or a nursing home.
Okay, so not just a doctor.
Not just a doctor. Traditionally, it is just doctors. However, it also would involve nurses. It can involve physical therapists. It can involve nursing assistants. Even though only doctors are allowed to provide treatment and diagnosis to patients, other allied healthcare professionals can also fall under the bailiwick of a medical malpractice claim.
I see, okay.
And a nursing home claim is similar, although there are not doctors in the nursing home or usually employed by the nursing home. It's a skilled nursing facility which only has nurses. It'll have nursing assistants, which are CNAs. Also have some physical therapists who are maybe contractors, and also occupational therapists. The medical director of a nursing home, which it's required to have, is an independent contractor, but you can also sue that person if you had to for negligence involving your care at the nursing home, but generally the nursing home only involves the care of the nurses and the people below the nurses.
Got it. All right. Now, if a procedure has gone wrong, let's just talk generally about medical malpractice, and then we'll focus specifically as to how this might apply in a nursing home or an elder care type situation. Something goes wrong or a procedure doesn't go well. What is it that someone should do, or how should they start the process to determine whether that's just one of those things that happened, or whether that's something that perhaps maybe there is an actual claim? What would be the first step, and then how is the process, or what is the process?
Okay, well, the process would be, you have to have let's say in the case of a doctor, you have to have a doctor-patient relationship, first of all, to have any potential claim. And with any tort, you have to have suffered an injury to have a viable claim. So if you are injured as a result of, let's say, medical care directly from a physician, I would say the first thing to do is, if you're truly injured and you have concerns about your care, you need to seek more care to get the injury taken care of.
So get it fixed first if you can.
Get it fixed if you can, but you can always take the step of trying to obtain your own medical records from the doctor's office. You're entitled to your medical records under federal law, and it is hard to investigate your own claims unless you're a medical professional, but sometimes there are obvious things where a medical professional will make a note that would show that something went wrong, let's say during a surgical procedure, but getting your medical records also helps. If you decide to retain a lawyer, then the lawyer doesn't have to go through the process of trying to obtain your medical records, which will generally take longer. As a patient, you can walk into the doctor's office, request your records. You'll generally get them that day. When you come to talk to an attorney, you have to sign a release. The attorney then just has to go and send a letter. Then you have to pay for the records. It can take
longer process.
It can take a month or two. So I would suggest that if you're injured and you think it's a result of malpractice, you should probably contact an attorney who focuses on medical malpractice claims versus just a personal injury lawyer who tends to focus on a broad range of
Automobile
claims.
accidents and things
Automobile
like that.
accidents, slip and falls, things of that nature.
Okay.
Estudiar una carrera puede tomar años. Incorporar un negocio, menos de un día. Perales y Fernández, para servirles. Si tiene un problema legal serio, es crítico que pueda hablar directamente con su abogado sin necesidad de un traductor. Perales y Fernández, Defensa Criminal.
Okay. So it sounds like the first process is going to be someone has to review these medical records. If you're the patient, you may have an inkling that there's something wrong, but it sounds like the lawyer is going to get it. Is the lawyer going to understand what it is, or does the lawyer have a medical professional take a look at it?
Well, both. So somebody like me who's been doing medical malpractice for about 13 years, I'm familiar enough with medical terminology and medical care that I can go through the records and spot things that weren't done correctly. However, if I think I'm good at that, I'm not clearly as good as any doctor there is out there. So what happens is if the lawyer thinks there's a viable claim, so they go through the records, they may have a nurse that they use, a legal nurse consultant that can also review the records, then they can sort of figure out if there's something more that needs to be investigated. Sometimes it's just what's called a complication of the medical care. There are a lot of things that are complications of the medical care. If it is a complication and there's nothing to pursue, then at that point we just tell the client there's nothing to pursue. If we think there is something to pursue, then we call up an expert in that field. Let's say if it's an orthopedic surgeon, we would contact an orthopedic surgeon who would independently review not only the medical records from the care, but any medical records from prior to the care and after the care, and get an overall picture of the patient. And then at that point, that expert would render an opinion to us if he thinks there's a deviation in the standard of care, or if he said the care was fine, and at that point we would talk to the client to see if they either want to file a lawsuit, or if they just want to, we would just say there's no viable lawsuit and we can't move forward.
You mentioned a term here, and it's a term of art that I don't know that laymen would really understand. You said the standard of care, and let me just back up a little bit. As you talk about this process, you talk about having a medical professional, particularly a doctor, in essence, affirm that in fact what had been provided was in fact in error, was below what normally is being provided. And I know a lot of times the issues come up about frivolous lawsuits and so forth, but in a medical arena, it seems as if what you're saying is that process is being done so that a medical professional says, I know what I'm doing, I know these what you're supposed to do in this circumstance, and I think there's a problem. Is that a correct sort of basis for having that other doctor take a look at it?
That's correct. And when I talk to a client when they come in, I always contrast a medical malpractice or a nursing home malpractice case to an auto accident case.
Okay.
If two people run into each other in the parking lot, all you have to do is you retain a lawyer, they file a complaint, and the lawsuit starts.
It's sort of easy.
It's relatively easy compared to a medical malpractice or any professional negligence suit.
Right.
So in a medical malpractice lawsuit or a nursing home malpractice lawsuit, the Georgia law requires that you have an expert who is as equally qualified as the person or persons you are going to sue. So if it's let's say it's a nursing home and you have a nurse that you think her care was below the nursing standard of care, you would have to talk to and retain an expert who is not only a nurse but has long-term care experience similar to the person you're suing.
Okay. So a nurse in a ward where they're delivering babies isn't necessarily, although a nurse, going to be able to testify or give appropriate evidence relating to care in a nursing home. It's a very different environment. Is that fair?
That's exactly right. And they don't have to be, when it comes to doctors, they don't have to be in the same specialty, but they have to perform the same procedures, or they have to be in the teaching profession. So if you have a professor at a medical school who may not provide much hands-on care, he or she can still testify against another person who's in a practice that provides hands-on care on a daily basis.
Nursing home cases, is there any particular difference in the pursuit of a nursing home case than a medical malpractice case that would be against a doctor or a hospital? And can you tell me what some of those differences may be?
Yeah, the biggest difference is the patient population.
Right.
You know, we generally go to the doctor, and you know, we're up until a certain point, you know, we're fairly healthy. We see our doctor maybe every once in a while. And if you go in the hospital, it's usually for some sort of procedure, but you expect to come out of the hospital fairly quickly. However, with a nursing home, it's an aging population, or it's people that need 24-hour nursing care, which is the whole point of a nursing home. So you could be younger, but you could still need 24-hour nursing care, so you have to go in a nursing home.
All right.
And so the issue is you have people that have a lot of illnesses and other issues that affect how they can heal, and it affects the care sometimes that they're given in the nursing home.
Let's do this. Let's talk about how that's going to impact the case in just a moment. We need to take a quick break.
Sure.
Be sure and join us when we're back at Leyes Cotidianas.
Desde el momento en que ellos llegan a nuestras vidas, dan su primer paso, aprenden a andar en bicicleta. Hasta la preparación de su primer día del 5º grado es un reto para todos los padres criar un hijo saludable. Permítanos guiarle a través de un embarazo seguro y feliz. Aprenda sobre salud, nutrición e información educativa relacionada con el desarrollo de su hijo. Padres e Hijos Atlanta, una publicación del mundo hispánico. Recoja su copia gratis hoy. ¿Cuál es su tesoro más preciado?
Welcome back to Leyes Cotidianas, our everyday law where we discuss the laws that affect you every day. Before the break, we were discussing medical malpractice claims, and in particular, some issues with regard to nursing home claims. Is there anything particularly problematic about bringing a claim against a nursing home, or particular issues on a nursing home claim that might be different from a claim, let's say, against a hospital?
There are a lot of times with nursing homes, you see medical issues that arise in the nursing home that you don't really see in a hospital setting, and that's because of the care needed and the sometimes the life expectancy of the patient themselves. So,
what kind of differences?
Well, I mean, sometimes you will see pressure sores are a major cause of concern in nursing homes. There are some reasons for that. However, say in a hospital setting, even if you're in there for an extended stay, generally the patient population doesn't get a lot of pressure sores or decubitus ulcers, which are also referred to. But in a nursing home setting, for various reasons, the population tends to get a lot of pressure sores or decubitus ulcers. If they're not treated properly, they can lead to major concerns such as gangrene and sepsis. Some other issues are falls are much more common in nursing homes than they are in a hospital setting, and other things such as the failure to assess the patient in a timely manner. And so if you're in a hospital setting, you have nurses that round on you fairly frequently. You also have doctors, a bunch of doctors in a hospital setting who also round on you, and depending on the level of care you're receiving in a hospital, you could be seen multiple times in an hour. In a nursing home setting where there is no doctor and it's just nurses, the nurses are only required to come and see you as ordered by the medical director, who is not present at the facility. So sometimes what happens in the nursing home is the patient may develop a problem that's not noticed until it's later than it should have been noticed, which in a hospital doesn't happen that frequently. The other issue in nursing homes that tends to occur more often is over-medication. It doesn't happen much in a hospital setting, but for some reasons in nursing homes, patients tend to be over-medicated. I'm not exactly sure the reason for that. They're only supposed to give the nurses are only supposed to give medications per orders, but sometimes they give more medication than they should, and that makes the patient lethargic, and the patient can't communicate properly. And finally, a lot of times the patient, if there is a problem because it's not noticed, they're not sent to a hospital for treatment quickly
in a timely
enough.
manner, right?
Right, because the nursing home can't provide the care that a hospital provides. For instance, nursing homes can't run IVs. So if you need any sort of IV medication, you have to go to the hospital. So the nursing home can't provide that, so they have to call the EMS or the ambulance, and then they have to take you over to the hospital for treatment. When a patient comes into a nursing home, there are some legal issues also involved. Arbitration agreements are becoming more frequent and common in the nursing home setting. And essentially what an arbitration agreement is it takes away your right to get your day in court.
Okay.
So if you have, let's go back to the car wreck example. If you have a car wreck case, you file suit against somebody else, there's no arbitration clause in your insurance policies, and you get your day in court if you want it, or you can settle the case outside of court, and you have your right to a jury trial. In a nursing home setting, if you sign an arbitration agreement, if the family member, the patient, signs the arbitration agreement, or if a legal representative of the family member, somebody has power of healthcare attorney or something, signs it, then arguably you're bound to the arbitration agreement. So
then you're outside of a court setting.
You're outside of a court setting. So if you're the victim of malpractice in a nursing home setting, you go through what we talked about. You get a nursing expert, you get an affidavit, you find there's a deviation from the standard of care, you put together the lawsuit, you serve the nursing home defendant. You'll then get some documents that say, well, hold on, you signed an agreement to arbitrate. We go to arbitration, which it takes you out of the court setting, and then there's a person, an arbitrator, similar to a mediator.
Like a private judge.
Basically a private judge who hears the case and decides the case, and most of the time it's actually binding. So you're stuck to that arbitrator's decision. Correct.
Okay. And there, typically in an arbitration, there's no ability to appeal it either. So you don't have an extra layer to take it above. Is that right?
That's right. You're basically stuck to that provision. Now the problem is, if you're a layperson, as most people watching this show are, when you take somebody to a nursing home, let's say that you have to take your grandmother to the nursing home. Well, the reason you're going to the nursing home is it's probably the one that had some available space.
Right.
And so you get there, and they accept your grandmother as a patient, and they give you literally a stack of documents and say, go ahead and sign these. And if you say, well, I don't want to sign some of these, they'll say, well, we can't accept your grandmother into the nursing home.
So you're sort of
at
their mercy.
Right,
on
you're at
that,
the mercy, and sometimes you get stuck into signing agreements that you didn't want to sign, but you really had no choice. So arbitration agreements aren't really prevalent with hospitals. Doctors' offices, to my knowledge, really never use that, anything like that.
But in the nursing home scenario, that's an extra wrinkle that might that folks may not be aware of, and probably are signing without any knowledge that they're even giving away that right. Let's talk now. Let's contrast that. So those are specifics regarding nursing homes. Let's talk a little bit about in sort of a typical medical malpractice claim, and then if there's a particular area of medical malpractice claims, like for example, if there's an emergency room scenario. So we've talked about kind of long-term health matters and then hospital matters. Let's talk a little bit about a regular medical malpractice claim against a hospital or a doctor, and then how that is contrasted with perhaps a problem that has arisen as a result of an emergency procedure or emergency surgery.
Okay, and if we go back when we were talking about the standard of care, that's the big issue that separates non-emergency care from emergency care.
Okay.
So the standard of care is what a doctor would do, a reasonable doctor would do under similar circumstances, to put it simply. And then as a result of tort reform in the state of Georgia in 2005, the standard of care applicable to emergency care was changed. So emergency room doctors are held to a much lower standard of care. It's essentially it's a gross negligence standard. So if you have a doctor, let's go back to our orthopedic surgeon.
Okay.
The orthopedic surgeon is held to a negligence standard, and the emergency room physician is held to a gross negligence standard. So essentially, it's the absence of care and skill that an emergency room doctor can give you. So if he gives you slight care, it can be, frankly, bad care, and it can almost be negligent care. It's not grossly negligent care. That's the standard that the emergency room physician has to deal with. The reason that was done purportedly was because those doctors don't actually see those patients. They don't know patient histories and things. What it's resulted in is some bad emergency room care where
it's gone unchecked.
It's gone unchecked, and you have one specialty. ER physicians are specialists. You have one specialty that is held to a much lower standard of care than the rest of the medical community. So for instance, if we're driving on the street, you and I have we have to exercise reasonable care. It's our duty when we're driving a car. But it would be like if you had a certain percentage of the population that could kind of do whatever they wanted to.
Those people that are late.
Right. They can drive faster, they can drive recklessly, but they're still within the law doing that, and you and I aren't within the law if we do that.
Accidentes de trabajo, daños personales, negligencia médica, defensa criminal, abogados Perales y Fernández para servirles. Estudiar una carrera puede tomar años, incorporar un negocio menos de un día. Perales y Fernández para servirles.
That is it for our show today on Leyes Cotidianas. Join us for this and much more at our website, leyescotidianas.com. Please like us on Facebook, and please view this show and all of our other shows on YouTube. Thank you so much.
Leyes Cotidianas les llega a ustedes gracias al generoso apoyo financiero de la Fundación de Justicia Civil del Estado de Georgia. Mundo Hispánico, el vocero de la comunidad hispana desde 1979.
Desde el momento en que ellos llegan a nuestras vidas, dan su primer paso, aprenden a andar en bicicleta. Hasta la preparación de su primer día del 5º grado es un reto para todos los padres criar un hijo saludable. Permítanos guiarle a través de un embarazo seguro y feliz. Aprenda sobre salud, nutrición e información educativa relacionada con el desarrollo de su hijo. Padres e Hijos Atlanta, una publicación del Mundo Hispánico. Recoja su copia gratis hoy. ¿Cuál es su tesoro más preciado?
La estación transmisora WKTV Telemundo Atlanta no tiene licencia para practicar leyes en el estado de Georgia. WKTV Telemundo Atlanta y los patrocinadores de este programa no son responsables por las opiniones expresadas ni la información proporcionada por los abogados en este programa. Este programa se ofrece como un servicio público. El objetivo de este programa es de informar y educar y no de proveer consejo legal. Si usted necesita consejo legal, favor de consultar a un abogado.